raise some interesting statements of legislative intent that I've come across. As the lawmaking branch of state government, the California legislature on occasion desires to express its intent regarding proposed legislation. In my mind, there are four forms of intent measures. The first is an intent bill, which is used for introducing a placeholder bill before putting substantive language into it. This form of intent describes what the bill is likely to become once those substantive amendments are placed into the bill. The following that I'll read is an example of intent bill language when a placeholder bill is introduced and before substantive language is put into the bill. It is the intent of the legislature to enact legislation to establish standards and requirements for qualification, payment, and reimbursement, supervision, and scope of eligible services. It is further the intent of the legislature to enact legislation to establish processes aimed at ensuring community health workers have the supportive structure in place to adequately serve community needs. The second form of intent is when legislative intent statements are included in the substantive language of a bill. These statements of legislative intent always begin with the introductory clause, "It is the intent of the legislature that." Now, sometimes these statements of legislative intent are clearly directed at the judicial branch of state government when the courts are called upon to interpret statutory language. And the following that I'll read is an example of legislative intent language directed at the judicial branch. The first one is, nothing in this section restricts the ability of the court to address bail consistent with the California Constitution or the United States Constitution. Perhaps a meaningless statement because obviously the courts have that ability. The second one example is, it is the intent of the legislature that any court which finds or in the process of reviewing a previous court finding finds that a public agency has taken an action without compliance with this division shall specifically address each of the alleged grounds for non-compliance. The third form of when legislative intent statements are included in the substantive language of the bill, but the statements are clearly directed at the executive branch agencies and departments that must apply or interpret or even enforce the statutory language. And sometimes these legislative intent statements are consistent with the regulatory agency's interpretation of the law. But in other instances, these statements may be contrary to the way in which an agency has interpreted the law. So the following I'll read to you is an example of legislative intent language directed at an executive branch agency. It is the intent of the legislature that this act's amendments of the Public Utilities Code do not require the Public Utilities Commission to modify its rules to the extent those rules are consistent with these amendments. The fourth form is when legislative intent statements are included in the substantive language of a bill, but the language represents a broad policy statement. And that statement isn't necessarily directed at either the judicial or executive branches of state government. These statements may be directed at a local government or even the private sector, or they may simply just be general policy statements of the legislature. So the following examples I'll read to you are examples of legislative intent language that represent several different circumstances. The first example is, it is the intent of the legislature that collective bargaining agreements be respected. Broad policy statement. The second example is, it is the intent of the legislature that the definition of gross revenues in this division shall result in local entities maintaining their existing level of revenue from franchise fees directed at local governments. The next example is, it is the policy of the state of California that subscribers and potential subscribers of a state video franchise holder should benefit from equal access to service within the service area. This is to a private entity, right? And the fourth example I'll give you is, the legislature finds and declares that unique circumstances exist at the San Francisco waterfront, and that therefore this act sets no precedent for any other location or project in the state. You may be surprised by this figure, but statements of legislative intent exist in over 10,000 instances in California statutes out of the 155 plus individual sections or statutes in the 29 California codes. Now, these statements of legislative intent can often be very important in interpreting or applying or even understanding the statutory language. And of course, receiving the guidance that the legislature is intending to be followed as a policy of the state of California in these individual statutes.